We're starting our next panel now, which is the panel on transformative use. The nice part about this is, and this is why we put it at the end, is that not only do we get to talk about transformative use, but we also have Jennifer's presentation, which will have a series of interesting slides on it showing things other than proteins or maps of educational institutions.
Bernd and I will be moderating each other, so I'm aspiring to be I'm the Ruth stand-in half of the tag team now. So throughout the day, we've been talking about copyright limitations and exceptions, and the principle that while we rightly focus on losses to content producers from copying, we should also, as we have been throughout the day, focus on losses due to failed sharing and failed innovation. We've already talked about these kinds of losses in some detail in the context of science, research, preservation, and I want to broaden that discussion and talk about the notion of transformative use. When the digital subjects of today want to engage, create, innovate on the internet and run into the copyright wall, when the law or practices and assumptions built on the law prevent value-added or transformative uses of copyrighted content. I'm going to talk about two puzzles of transformative use, two ideas that, while at first glance they may seem slightly different, I think when taken together help to reinforce many of the themes that we've been discussing today. The first puzzle is the paradigmatic case of transformative use. This is when the citizen publishers of cyberspace, newly empowered, use copyrighted content to create mashups, satire, parody, collages. This is done by a group of generally unpaid people who put their new creations online for free to make a point, to enter a political discussion, to make their audience laugh. And also uses that we talked about today, adding value to reference works, some of the interesting examples of maps that John showed, showing there are maps showing where Hurricane Katrina has damaged things. You were showing deforestation. You were showing maps, overlays, showing nighttime lights in cities throughout the US. The wonderful IHOP example that you showed that takes scholarly articles and actually creates something that's much more useful to researchers. All of these could be considered transformative uses of copyrighted works. Larry Lessig has coined, I think he coined this, I don't know, now I know Jerry was not the originator of Wiggle Room, has coined the term remix culture to describe this phenomenon. And the first question is, how, if at all, should copyright law be adjusted to deal with it? Do we maintain the status quo, wait and see? Do we flatly forbid these kinds of uses? Do we expand fair use or fair dealing? Do we come up with more creative solutions? I'm going to return to that later. That's the first puzzle. Now, the second puzzle is slightly different. The second puzzle is the attempt by a series of US courts to grapple with the legal definition of transformative use as a component of the fair use analysis in the context of a series of cases involving, among other things, search engines. So the first puzzle asks us how copyright law should deal with remix culture. The second puzzle is why US courts conscientiously trying to uphold the goals of copyright, namely not only the production, but also the useful dissemination of content, knowledge, and culture, would define the concept of transformative use so that it extends well beyond the familiar concepts of satire or parody or even a mashup to encompass the use by a commercial search engine of visual or textual thumbnails in order to facilitate the process of internet searching. My claim is going to be that each of these puzzles can teach us something about the other. So first, let's talk about perhaps the more familiar one. The reuses of copyrighted works that have been enabled by digital technologies and the internet. Here again, we have the newly empowered masses suddenly subject to copyright law and all the creative and socially valuable works that they're producing. I mentioned some of those already, Wikipedia, map overlays, and no presentation about transformative use should go by without showing a couple of mashups, or at least that's my opinion, because they're fun. And many of you have seen this before, but for the few of you who haven't, I present Bush Blair.
My love, there's only you in my life, the only thing that's right. My first love, your every breath that I take your every step I make. And I want to share all my love with you. No one else will do. And your eyes, they tell me how much you care. Oh. Now read my lips, take dictation.
So that's the brilliant lip sync.
Use 672.
But actually, this is one of many instances of this posted on YouTube. So to really get an accurate count of views, you'd probably have to add all of them up. But this is an instance of what Jamie calls long winters syndrome. This is another one of our Scandinavian friends. In this case, a Swedish film.
People who cracked CSS give you.
Yeah, exactly. This person's not Norwegian; he's Swedish, Johan Soderberg, and he went through a whole lot of work to lip sync news footage of Tony Blair and George Bush to the song "Endless Love" by Diana Ross and Lionel Richie. I don't know if you recognized it; really sappy tune from the '80s. And the question is, well, is this fair use? We could probably make arguments on either side. The main copyrighted work that's used in there is the song "Endless Love." A lot of that song is used. The Swedish gentleman is not poking fun at endless love, right? He's not necessarily making a commentary. It's just about how vacuous, empty, cheesy, and silly songs from the 80s are, that particular song. He's making fun of the cozy relationship between George Bush and Tony Blair in the context of the Iraq War and foreign policy. So we could argue either way, but the question is, should we enable this? Should this fall into some sort of legal exception? I'm going to show one more because I think it's another really worthwhile example.
Again, a conversation with all of you, and so far, we haven't stopped talking, and that's really good. I intend to keep telling you exactly where I stand on all of the issues.
I'm looking at how to help you and other people who are hardworking like you, and I've really been impressed by how serious people are.
Because we all need to be part of the discussion if we're all going to be part of the solution.
I don't want people who already agree with me. I want honest, experienced, hardworking, patriotic people who want to be part of a team, the American team. I hope you've learned a little bit more about what I'm believing and trying to do, and really helped this conversation about our country get started.
I hope to keep this conversation going all the way to November 2008.
Has everybody seen this one? No. So this was neither authorized by Apple computers nor the Obama campaign. This was an Obama supporter who took Ridley Scott's 1984 Big Brother Apple advertisement for the Super Bowl. Hillary Clinton is the Big Brother figure, and the mindless drones of her followers are running around, and it's sort of, signaling the time for a generational change in politics. Again, a copyrighted work is used, in this case, not to mock the commercial, but to make what would seem to be a political point. So this is all the stuff we see out there. So my contention would be that copyright law, while preventing certain kinds of copying, should find some way, private solutions, public solutions, to facilitate these kinds of creative, interesting, value-added uses. So that's the first puzzle. We'll flag that. Now on to the second puzzle. In the US, fair use, as I think all of you know, has as one of its crucial questions an inquiry into the nature of the use. Is this a commercial use or a nonprofit educational use, for example? But in a series of cases, US courts have told us that these are not the only kinds of uses. The commercial, non-commercial dichotomy is not the only question. What about the situation where someone makes a parody of a copyrighted work but distributes the parody commercially? There, the Supreme Court, in the landmark case of Campbell versus Acuff-Rose, told us that if the use is transformative, drawing from a 1992 article by Pierre Laval, if it alters the original work, quote, with new expression, meaning, or message, we should not automatically apply the presumption that commercial uses are illegitimate or that there's automatically market harm. Transformative uses carry no such negative baggage. In In the Acuff-Rose case, the kind of transformation the court had in mind was not the same, but sort of similar species to that in some of my remix culture examples. For those of you who haven't read the case, in that case, the rap group Two Live Crew took Roy Orbison's song Pretty Woman, some of the music, some of the lyrics, and rather than quoting the lyrics, I'll just quote Justice Souter. The song was transformative in that it juxtaposed the romantic musings of a man whose fantasy comes true with degrading taunts, a body demand for sex, and a sigh of relief from paternal responsibility. So that is the elegant description of how the Two Live Crew song was in fact transformative, and in fact described in some detail a big hairy woman and a bald-headed woman, but I won't belabor that. So here one author was effectively trumped by the second author, whose use was privileged because it transformed the copyrighted work in order to parody, comment, ridicule the work. And many people have pointed out, people in the library community, that privileging this category of uses over others could short-shrift some very important instances of fair use, multiple copies for classroom use, archiving, indexing, etc. So this takes us to the second puzzle that I mentioned, two noteworthy cases from the Ninth Circuit in California, Kelly versus Aribasoft and Perfect 10 versus Google, in which the courts were dealing with a different kind of use in which thumbnails, reduced size versions of photographs, in one case photographs of the American West, and the second case photographs of nude models, were created by search engines and used by search engines in the course of indexing photos on the internet. The thumbnails told the user that his search had in fact turned up the right image, and text wouldn't do in this case because you need to actually see the image to decide, oh yes, this is what I was looking for. So the thumbnail in this case stood for the work. It was the signifier, but not the signified. This, the court said, was significantly transformative, and I'll quote from the Perfect 10 case. Although an image may have been created originally, so this would be, in this case, the images of nude models, to serve an entertainment, aesthetic, or informative function, a search engine transforms the image into a pointer, directing a user to a source of information. So here, in the court's opinion, the search engine provided a social benefit by transforming the original work, an aesthetically pleasing work, into a social reference tool. The function of the work is transformed. The other side argued, they said, but they didn't add anything to the work. This is the same thing. They didn't add anything to the photo. They didn't really change it. They just reduced the size. And this court said, well, that's not the important thing. The important thing is the purpose, the use, the function of the work is completely transformed. Hey, Hiroki, can you just scroll over? So this was the site at issue in the first case, just to show you. Aribasoft changed its name to Ditto. Has anyone here not used Google image search? So instead of, I was going to show you the nude models, but I thought that would probably be inappropriate for this conference. And so in honor of John, I'm showing a puppy. So you see, so you pull up. So here you go. So here's the question. So, these are copyrighted images, some of them of puppies. And Google has taken them. A reproduction has been made, turned them into thumbnails. And if you click on them, you're taken to the site where the actual photo is framed by Google's information. Is this transformative use? Well, US courts have said yes. In this case, the court emphasized that Google used, as I said, Perfect 10's images to serve a different new purpose, and kept in mind explicitly throughout its analysis the extent to which they felt that this purpose, helping people find copyrighted works, actually serves the goals of copyright, useful dissemination of knowledge and culture, and also serves the interests of the public. And they also found noteworthy, Google's not in this, Google makes something of a profit, that the significantly transformative nature of the use did in fact outweigh the commercial nature of the use. So note the difference here, and Jamie alluded to this in his introduction. The court seems to view it as mere happenstance that in the process of making the index a benign purpose that fosters the goals of copyright, there was a copy made, perhaps a public display. The process of making the index implicates the copyright owner's exclusive rights under 106. But the court thought the search engine simply wants to enable searching. If this can be accomplished without copying, terrific. But if copying is a necessary part of the process, this should not necessarily doom the enterprise. Back in the analog world, you could make a concordance. I did so laboriously when I was in graduate school. I wrote down every time the word fair, ironically, fair use came up in Milton's Paradise Lost. It took a long time. If you can do it without implicating 106 rights, that's great. But in the digital world, Google does it by scanning copyrighted books and showing snippets where the search terms appear. This is the Google book search litigation that's going on. A concordance of all of the millions of books that they're scanning, but in the course of doing so, making copies of the copyrighted books. Is this transformative? I would say yes. I would agree with the Perfect 10 Court's reasoning and apply a principle of technological irrelevance or neutrality. Indeed, I have to quote Professor Reichman again. If the law treats this kind of copying as functionally identical to piracy, then I think it is indeed normatively blind as a bat. And wiggle room should be retained for that. So the second puzzle is looking at transformative use in the context of its legal definition, not this broader use enabled by the internet, but this legal definition, and in terms of not only looking at traditional value-added creative transformations, but uses which change the purpose to which the work is put. So how do these puzzles illuminate each other? Well, in both of them, a technological and cultural change demands that we revisit the meaning of copyright. Jamie alluded to this also during his introduction. How am I doing on time? I have trouble keeping my own time. So during most of the 20th century, the copyright system was an industry compact. It grew up in a world where it was relatively hard for individuals, people, regular schmoes to infringe copyright. You would need a printing press or a movie studio. How do we adjust when now millions of people have the tools to copy, transform, republish, when everyone has effectively a printing press and a digital remixing studio too? One answer is that we should focus on the enormous potential for infringement. Laws must be strengthened. Digital fences must be backed by state enforcement. We should drag all copyright infringers to jail. Well, the ease of copying is a real problem and one that deserves our attention. But if we see the democratization of the tools of cultural dissemination only as a threat to the copyright system, we are blind indeed. And I know I'm preaching to the choir here, but if you think about the examples, I'm sure you get these in your email all the time, of transformative use that I gave earlier, the countless ones that John showed us or that you use in your daily life. This kind of creative, expressive exercise of free speech and inquiry is something to celebrate and something we definitely do not want to stifle. At the very least, we need to think about the balance between the interests of the original creator and the interests of the subsequent modifier, remixer, transformer, and also of us, the wider society who gets to enjoy these works. So what about the second puzzle, the thumbnail cases I talked about, where the use is for a transformative purpose? I would say the same general ideas apply here. We can look at copyright formalistically, could see the indexing of the web as mere piracy, could see the thumbnails as straightforward reproductions. In fact, this is the argument that is being made against Google in the Google Book Search case. But to miss the fact that indexing now requires large-scale copying to be effective, that copyright's triggers have been accidentally tripped in the course of an attempt to further copyright's actual goal, finding the information that you need, finding the copyrighted works that you need. This would be missing a critical part of the picture. So the conclusion is, what do we do about this? There are many ways to deal with these issues, and since I think a lot of people have proposed 4 principles, Jamie proposed 4 things, I think Ruth proposed 4 things, I'm going to propose 4 guiding principles of my own to deal with transformative use. First, a relentless focus of on the goals of the copyright system. Again, to promote the distribution of knowledge and culture, rather than on words or formalistic legal definitions. A copy was made. There's a copy somewhere in your cache, there's a copy somewhere in your RAM. Goals of the system, and if you read the cases that the 2 cases I mentioned with the thumbnails, they relentlessly return to, look, we really need to look behind what's going on, behind the literal word fact of a copy, and look at whether the goals of copyright are being served. So that's 1. 2, and this is what we've been doing here all day, take into account the losses that come from failed sharing and failed innovation, not just losses from copying or a failed theoretical new royalty stream that was not captured. And we've discussed how perhaps the losses from failed sharing are difficult to quantify. Mike made the good point, though, that sometimes that's the burden's actually on the other side, not the side saying, well, show me all the work that didn't get done, show me all the innovation that didn't get done. But as we also discussed, there are some economic studies going on that are going to be showing just that. And there are also, stories, anecdotes, well, this is what I would have done if I wouldn't have run into the copyright wall. So first, goals of the system. 2, we're doing it already, but as a broader matter, focus on losses from failed sharing and innovation. 3, be open to new schemes that protect both the original author and the second comer. Jerry has written maybe an article or two about liability rules. So, maybe privilege non-commercial uses, but when the use becomes commercial, maybe apply sort of liability rule. So when the use becomes commercial, take now, pay later system. The rig mixer can take now, use the work, right? But ultimately, a non-discriminatory flat rate fee will be paid back to the original creator, some sort of remuneration. That's a possibility. We've talked about top-down approaches, legal reform. There are proposals for alternative compensation systems out there. We've talked about bottom-up approaches, Creative Commons. Ruth was mentioning, the network, sort of network changing the norms that we assume. So there are a lot of approaches out there, and we mentioned, WIPO thinking, well, we can't think about open source because it's our duty to protect intellectual property rights, but it's critically important, third principle, to be open to new schemes. That's what we're here doing. We actually have a chance to get it right. It's become a cliche that copyright lags behind technological development, but here, these transformative uses, they're relatively new. We have a chance to think about it. Some of the more interesting proposals have been written in law review articles by people in this room. Think about them not only in conferences like this, but in the broader arena. And finally, number 4, I had to push for this one because I really only had 3. But I think these 2 puzzles teach us that we should take a transformative view of transformative use. Thank you.